This court is now in session. The Honorable Alan Stevens presiding.
Thank you. Please be seated. Good morning, ladies and gentlemen. We're going to go on the record in two Bonneville County cases, CV 15-2418 and CV 16-2549, both entitled Christopher Tapp versus the State of Idaho. Hello, Mr. Tapp. Looks like Mr. Tapp is here with his counsel, Mr. Thomas. Mr. Thomas is who's with you at counsel?
Your Honor, this is Jennifer Cummins. She is with the Idaho Innocence Project. She's their staff attorney, and she filed an appearance a couple months ago.
Okay, thank you. Welcome. And we have Mr. Clark and Mr. Dewey from the prosecutor's office representing the state of Idaho. Okay. Well, the purpose of this hearing today is for the court to review a stipulation for disposition and to determine whether or not the court can accept the stipulation, which would resolve the two civil cases that I've called, as well as possibly another civil case in Bonneville County, which is up on appeal, CV 12-5881, and potentially, should I agree to this stipulation, CR 1997-481. So, gentlemen, I have been supplied and ladies, I've been supplied a stipulation for disposition that appears to be signed by Mr. Tapp, Mr. Thomas, and Mr. Clark. Is it still the intention of the parties to move forward on this stipulation today?
Yes, Your Honor, from the state.
Okay.
Yes, Your Honor, and I'll acknowledge my signature as well as Mr. Tapp's signature on that document, and we are prepared to go forward.
Very good. Okay, well, Mr. Clark, on behalf of the state, would you, for the record, state the important portions of the stipulation?
I will, Your Honor. As the court has referenced the stipulation that's been filed by the parties to this court, I will reference that at this time. The gist of the agreement is the defendant agrees that his conviction in Bonneville County case number CR 97-481 of the charge of count 1, murder in the first degree of a principal, and part 2 of a deadly weapon enhancement, those convictions shall remain in full force and effect. Parties agree that the defendant shall be afforded a post-conviction relief in Bonneville County case CV 2015-2418. And the parties further agree that a resentencing occur in Bonneville County case number CR 1997-481. The parties agree to a unified fixed sentence of 20 years plus any additional time served to today's date, served by the defendant, with the defendant receiving credit for time served. The parties agree that the court shall vacate the sentence and the enhancement in count 2 of the rape charge with prejudice. The defendant agrees to withdraw his appeal in Bonneville County case number CV 2012-5881. The defendant further agrees to dismiss with prejudice Bonneville County case numbers CV 2012-5881 and CV 2006-2549. The defendant agrees to waive all future claims or causes of action for post-conviction relief relating to the conviction in Bonneville County case number CR 1997-481. The defendant further agrees to withdraw and dismiss with prejudice any federal claims currently pending.
Thank you, Mr. Clark. Mr. Thomas, does that sound accurate?
It does, Your Honor, except for paragraph 5, Mr. Clark just erroneously referenced CV 2016-2549 He indicated it was CV 2006 2549. It was just a scrivener's error, so we'd ask the court. It was accepted.
Very good. Okay. Well, this court has to determine whether or not it can accept the stipulation, and so there's a little bit of a process that we need to go through to get to that point. Mr. Thomas, you've indicated that your signature is on this stipulation as well as that of your clients, Mr. Tapp. So I just need to ask you a few questions in that regard. Do you believe that you've had the appropriate amount of time to discuss this with Mr. Tapp?
Yes, Your Honor, we've discussed it on a number of occasions over the past several months, and I believe that Mr. Tapp is fully engaged and fully aware of the negotiations that we're going forward.
Have you explained the consequences of this stipulation if the court accepts it?
Yes, I did, Your Honor.
Okay. Have you answered any questions that he had about the stipulation and potential consequences?
Yes, Your Honor. There were quite a few questions, and we had quite a few discussions about a number of the issues, and we had ironed them all out prior to signing the stipulation.
Okay. So before your client signed the stipulation, did you go through each line of the stipulation with him?
Yes, Your Honor. We read it together, albeit through the glass, but we read it together. He read it as I read it. I held it up for him to read as I was reading it.
In your opinion, during that process, was your client in such a state of mind that he could understand what was going on?
Yes, Your Honor.
Okay. And do you consent to the disposition of these cases as set forth in the stipulation?
I do.
Do you consent to this court taking jurisdiction for resentencing if I accept this stipulation in CR 1997-481?
Yes, Your Honor. I think that's appropriate.
Okay, well, Mr. Tapp, in order for me to accept this stipulation, I'm going to need to ask you a few questions. Would you please pull that other microphone up to you, sir? And make sure that when you answer my questions that you speak into that microphone.
Yes, sir.
Mr. Tapp, do you believe that you've had an appropriate amount or sufficient amount of time to discuss these cases and this stipulation with your attorney, Mr. Thomas?
Yes, Your Honor.
Has Mr. Thomas answered all the questions that you had about the consequences from the court accepting the stipulation?
Yes, Your Honor.
Okay. Did you read the stipulation, every line of it, before you signed it?
Yes, Your Honor.
Now, I'm going to put you on the spot. Would you tell me in your own words, you don't have to give me all the details, but tell me in your words basically what you understand the stipulation means or what it says.
I am agreeing to principle of first-degree murder with a deadly enhancement charge, dropping all post-conviction relief, and counts 2 will be dismissed to a specific term of 20 years, plus extra days, whatever, of what's been served on this case.
Okay. So you do understand then that if the court accepts this stipulation and amends the sentence in case 1997-481, that you would still be convicted of first-degree murder with a weapons enhancement.
Yes, sir, I understand.
Okay. You also understand that the state, in exchange for that, would be asking this court to dismiss count 2 in case 1997-481, which is the rape charge.
Yes, Your Honor.
And vacate any sentence that was set by the judge on that count.
Yes, Your Honor.
Okay. Now, you give up your rights, if I agree to this and re-sentence you, you give up your rights to continue forward on these 2 Post-Conviction Relief Act cases that are before me at this time. You understand that?
Yes.
Okay. You also waive your right to continue the appeal from the case, from the Post-Conviction Relief Act case that was decided by Judge Tingey some time ago, which I believe is case, I think that's case CV 12-5881. You understand that?
Yes, Your Honor.
And you also give up your right to appeal the judgment that I would enter in the resentencing.
Yes, Your Honor.
And you give up your right to file a Rule 35 motion for me to reconsider that judgment.
Yes, Your Honor.
Okay. You, as I understand the stipulation, you would also give up your right to bring any future post-conviction relief civil actions.
Yes, Your Honor.
Okay. And do you understand that you would still owe the court costs or the fines that were set forth by Judge Wood when he originally sentenced you? I think that was in the amount of $78.50, and then there was a crime victim compensation of $2,500. You would still owe those amounts.
Yes, Your Honor, I understand.
Okay. Now, Mr. Tapp, have you had any questions about this proceeding or about the effect of the stipulation that your attorney has not been able to satisfactorily answer for you?
No, Your Honor.
Okay. Do you consent to me taking jurisdiction in case 1997-488 or 481, the case where you were sentenced by Judge Wood? Do you consent to me taking jurisdiction in that case for purposes of resentencing if I agree to this stipulation today?
Yes, Your Honor.
Mr. Clark, will there be any victim impact statements today?
There will, Your Honor.
Okay, let's take care of those statements at this time.
We'd like the court to first hear from Carol Dodge.
Okay, the court would be happy to hear from Ms. Dodge. Ms. Dodge, if you'd come forward and it's not my usual courtroom, so I'm not even sure where the witness box is.
That's okay.
Apparently you found it. Okay, go
Yeah.
ahead and have a seat. Thank you. Go ahead, Ms. Dodge.
I'm just overwhelmed. Sitting here today, a whole flood of memories came back, Chris, the day that we stood here and chose your jury. The jury that convicted you. Little did we know what we know now. And with great sadness, 20 years of your life has been taken from you. I can't even possibly imagine or even begin to comprehend living for 20 years, being confined to a 4x8 cell with nothing but a cot and a pot and no window to throw it out. And then to make it worse, it's surrounded by concrete walls and steel doors and wire fences. I can't imagine that, knowing what we know now, that anyone can convict someone that there's no DNA. But we've learned a lot, Chris, a great deal. I have definitely learned a lot. For 13 years, I was really angry at you, and of course you were angry at me. I remember visiting you in Pocatello at the jail, asking you what my baby's last words were. Little did I know that you just didn't know. I didn't know. It took me 13 years, Chris, to read over and over and over again and watch the videotapes of your interrogation. They're long. You can hardly hear them. They're agonizing. They're disgusting. And I don't know that anyone who has put judgment on you, Chris, through all this whole time, has ever really sat down other than Judge Heavey, Thomas, your attorney, who has put an enormous amount of work into this to set you free. You're not actually going free, Chris, but you're a long ways from where you were yesterday. I stand here today not as a victim, but I am a survivor of a horrific crime that took my daughter's life. Although she's not here physically today, she's here with all of us in spirit. I am her voice, and her message is loud and clear. As I wrote this last night, I just know that she was with me every step of the way. Thank you to everyone who has given so much that has brought us to this day. Everything will be okay. Everything will be made right in time. And there is a reason and a season for all things. Have faith. There will be justice for all one day. Then as I sat and thought about it and talked to my son Brent last night, I said, what would Angie say? What would really Angie say today to you? And I just have to share some thoughts with you, Chris. She said to me, she says, Chris and I both know that going backwards is not part of the Creator's plan. However, 20 years ago, we were fancy-free with little worry. We were hanging at the river, sitting on the boat dock, watching the river of life rush by. Those were the fun days, the days of laughter, the days of high fives. Then suddenly, as the sun set on the evening of June 12th of 1996, everything was about to change in all of our lives. And all of the river rats would go away. Little did I know it would be my last hours on earth. Little did you know that 6 months later you would be facing life in prison, locked in a cell with steel doors. Now it's 20 years later. That's an earthly time. And your beginning is just the new beginning, and it's going to set you somewhat free. Today is a new chapter in the book of your life. Go forward without bitterness and without a hardened heart. From this day forward, it's up to you of the path that you choose. Your new journey is not going to be an easy one, Chris. But stay clean and stay sober. Stay on track. When you feel strong, you take big, giant steps. And when you're weak, lean on your higher power. Your mother has loved you unconditionally, Chris, through all of this. And now it's time for you to give back. And last night when I talked to you on the phone, you promised me that. I always remember that when all the people that gave all this to you to set you free. Never forget who played a big part in your life. They brought you to this day. Now, you need to go forward and give back, and give freely of yourself and pay it forward. Peace be with you, my friend, Angie. I've worked hard, Chris, to bring this day forward, and it's like I said, for 13 years, I had a bit hardened heart, because for 13 years they programmed my mind to believe that you were part of my daughter's killing. And I'm grateful to Greg Hampikian for the day that I made a phone call that I told him who I was, and he said he couldn't help me because you had written to the Idaho Innocence Project and he represented you. And I said, oh, well, that's not why I'm calling. I just need a question answered. And it was in regards to the hair that was found at the crime scene. And I remember reading Greg Hampikian, the statement from the Idaho Falls Police Department and from the Idaho State Lab. And it said, the hairs tested are similar or same as the victims. And I just did understand that, Chris. I go, life isn't either or. Either it's black or it's white or it's sunny or it's not. It's day or night. And I thought, they're either Angie's or they're not. Well, back 20 years ago, Chris, technology isn't what it is today. And so we proceeded forward, and I had Jim Hoffman locate the hairs that were down in the evidence locker that got overlooked, and they were sent in for testing. And they came back, of course. A few of them were Angie's and 2 of them were the semen donors. Then I went on another journey and had the skin cell testing done because they programmed me to believe that you're the one that cut her chest. And that's not true, because when the skin cells were tested and they tested her clothing, your DNA wasn't found. And then I proceeded on and I read about a new research called MVAC. MVAC was just an unbelievable technology. And I took it to IFPD and I said, this needs to be done in Angie's case. And so with the help of West Jordan Police Department, Sorensen's lab, that was done. And the results came back and it excluded you and Ben Hobbs. Then I furthered my research and I read about the snapshot. And it was just announced, as you all know, last night that we have a composite drawing that new technology has given us through the killer's DNA, a picture, a composite drawing. And I have seen that picture, and he doesn't look familiar. I don't know who he is. I don't know that I'll ever know who he is. I don't know that he's alive. I don't know where he's at. I can tell you that it's been one hell of a journey, and I have turned to every pebble there is. And you've had a lot of people, Chris, working really hard to bring you to this day. Although it's not the deal that your mother wanted, it's not the deal I wanted, it's just not a deal. You know, life is no deal, deal or no deal. But you know what? It's a sentencing that for right now will set you free. Somewhat, Chris. 2 weeks ago, I was on the phone with Danny Clark. It was 3 o'clock in the afternoon on Saturday. And they were just getting ready to go over to the jail to have you sign a piece of paper that Chris would never have given you the chance that you have today. And when I heard it, I said, absolutely not. This can't be. And I remember Danny Clark saying to me, what the hell do you want? And I said, he has given 20 years of his life, set him free. And that resonated in Danny's mind. I said, he doesn't need to have probation because it's just another ticket back to prison. He doesn't have a life if he's strapped with a rape charge because it wasn't his DNA. So today, Chris, the rape charge has been taken away. You don't have to register as a sex offender. You're not strapped with probation for 10 more years that we all know would have been the most horrible sentence. You'd have been safer in prison. So like I said, go forward. Be grateful. Stay in touch with everyone that has helped you. Look for some great support team because it's not going to be easy, Chris. Today, if the judge allows it, you're going to be walking out as broke as you were the night of June 12th of 1996. But I asked Danny Clark, what will he do? And Danny said, there's a lot of programs out there. You just have to go find them. So there's a challenge that I give you, Chris. You have a lot of friends here that hung at the river. The river rats are here. There's a lot of victims from this horrific, horrible thing. I can't tell you of all of the people that are victims. I think every person in this room is a victim of unjust in some way or another. And you ought to be very grateful that 20 years ago, all those kids back there are here for you today, Chris. And I hope that you will help me find justice for Angie. Sadly, I don't see any of the police department here, the ones that promised me that they would continue on. Danny has promised that to me, that as long as he sits in the seat as a prosecutor, he will continue on. And I'm saddened that I don't see any of the Idaho Falls Police Department here representing my daughter, saying that they'll help me find justice. I was so saddened. But I'm extremely, extremely happy for you that you have your life back. Somewhat, just a little bit. And you have your mom. And you take care of her. Thanks.
Ms. Dodge. Mr. Clark, did you say there was another victim?
Yes, Your Honor, Angie's brother Brent Dodge would like to make a statement.
Mr. Dodge, if you'd come forward. Go ahead, Mr. Dodge.
Well, Mom, I appreciate your comments, and this is quite a day, Chris. Last time we stood face to face, it was a different conversation, and I was wrong. And I was having a conversation with a friend recently, and he asked me what I hoped was the result of this proceeding and this agreement. And we were talking back and forth about the agreement and all sides of it, whether or not it was appropriate, whether or not it was what we wanted, and so forth. And I don't really think that we came to any conclusion that was definitive and made us feel really good about either one of them. But he introduced a theme, and that was healing. And he had hoped that healing would take place. And as I thought about that, that seemed to resonate at a very deep level for me. And although the agreement's not perfect, it does provide the catalyst by which healing can begin to take place, and continue to take place. Some of us were at different places where we're healing, and some of us will continue, and some of us will just begin. And I mean, in terms of healing, not only our families, but the community, the public servants that have worked on our families and your family's behalf to see this through, and for which we're grateful. I'm grateful. I guess that's the message for me, is to remember this day as a catalyst where change took place, healing takes place. And you have quite an audience. As I was walking in, there's quite a number of cameras. And so I guess the second part of my message is that those of you who are the messengers that have the ability to share the message beyond this courtroom, which you do, we all need to heal. And that would be the message that we hope that you would spread and take. Finally, that's what my sister would want. She would want healing. And ultimately, we hope that the message that is carried beyond this courtroom is that we find who was responsible, who was the DNA donor, the one that wielded the knife that ultimately took my sister's life, so that the healing can continue and be complete for us. And so, Your Honor, we, on behalf of our family and Angie, we absolutely would recommend that Chris be set free. Absolutely. And so.
Thank you, Mr. Dodge. Okay, well, Mr. Thomas, would you like to make a statement on behalf of your client as to why this court should accept the stipulation as opposed to proceeding to trial on these two civil cases that are present before the court.
Your Honor, I came in here today to give the court a long list of reasons. But hearing Brent Dodge and Carol Dodge, I certainly don't want to take away anything from them. I think that all the parties involved, all the parties who are, everybody who needs to know knows that this is the right decision, that this is the right move. And I would just ask the court to accept the stipulation with that.
Thank you. Mr. Clark, would you like to make a statement on behalf of me accepting the stipulation?
Thank you. I appreciate council's comments. I thought similarly as we were hearing from Carol and Brent. I appreciate their comments. I think they're well reasoned. I think they come from a perspective that I think we'll appreciate. I think council said it best. Those that are involved with where we're at today, the current legal posture, the burdens of proof, the evidence as it is, and so forth, I think necessitate and suggest that a remedy that we've put before the court is appropriate. We believe that it's just, and we believe it's fair in considering all of those factors in light of the evidence, as well as the concerns and the questions that have been raised in recent past. And based upon that, we'd ask the court to adopt this agreement.
Thank you, Mr. Clark. I'm assuming, Mr. Clark, that based on the stipulation then that the state of Idaho agrees to me taking jurisdiction in Bonneville County case CR 19-97-481 for the purpose of issuing an amended or resentence in the judgment of conviction in that case.
We do, Your Honor.
Okay, thank you. Well, Mr. Tapp, this court has spent substantial time in the two civil cases that are before it today. Not as much time as your attorney and the state's attorney have spent. They obviously know more about the case than I do. There's reasons for that, because judges are supposed to hear evidence at trial that is admissible. But I do know a lot about the cases. I recognize the significance of the allegations in those two civil cases before me, and recognize that there is a substantial question in both cases as to who would prevail if they proceeded to trial. And when there are questions, that often leads to a resolution other than a trial. That's why we're here today. If there weren't any questions, I would have already ruled on those cases. I also recognize the impact that the ruling that I make today will have on not only the victims, but also on yourself and the public in general in the state of Idaho. I believe that both the attorneys for the state and your attorneys have worked diligently to reach a resolution that, in my mind, fulfills the needs for justice and fairness. And therefore, I can tell you that I've had time to review this and think about it overnight, talk to both counsel about it. And I do accept the stipulation, and since it requires a binding sentence on me, I have to accept that in order to proceed. I believe it's a reasonable resolution of the cases. And therefore, since both Mr. Tapp and his counsel and the state have stipulated that this court has jurisdiction in the two civil cases that are already before this court, as well as the original criminal case, CR 1997-481, I hereby rule as follows. The defendant, Mr. Tapp, having been found guilty of the charge of murder in the first degree and Part 2 deadly weapon enhancement, that the defendant is guilty of that offense. That his sentence on that offense is amended to a unified fixed term of 20 years, plus any additional time that you, Mr. Tapp, have served up to and including today, March 22nd, 2017. That the fine or court cost of $78.50 remains in effect, as does the crime victim compensation of $2,500. You are receiving credit by order of this court for all the time served today, up to today, with the intent that you be released from custody today from your sentence having been completed or satisfied. Count two in that case, 481, the rape charge is hereby dismissed with prejudice, and the sentence on that count is hereby vacated. The court also dismisses Bonneville County case CV 16-2549 and CV 12-5881. That's the appeal. Mr. Thomas and Mr. Clark, in your opinion, has the court forgotten anything? That's my catch-all to make sure we don't leave here today without all the...
Not from the defense, Your Honor.
Not from the state.
Okay. Well, Mr. Tapp, I'm going to sign an amended judgment of conviction, which basically says what I've just said on the record, so that the clerk can hand this to the sheriff, Bonneville County. Today is the 22nd, right? So that he can make the appropriate connection with the folks at the Department of Corrections in Boise, with the intent that as soon as those connections are made, you will be free to go. I don't think I can add anything to what's been said today, Mr. Tapp. I just wish you the best. I thank counsel for the state and your counsel for hard work, diligent work. I appreciate everyone in the audience being what's the best word? Very attentive. I didn't have to tell anybody to sit down and be quiet, so I appreciate it. And we are off the record, and everyone's excused. Did you have a question?
No, we're good.
He was good. He was proud. Please, he was proud. He was proud. Please, forgot. You don't let me know that. You all that you can do for her, Christopher. If it wasn't for her, you wouldn't be where you are today. I love you, Mama. I love you. I love you.
I'm going to say a few words here, if everyone wants to hang out. I appreciate everybody being here. You know, without you guys, this really would not have come about. It's the turning of the public and the turning of the people who were once against Chris, who have now turned towards him. We really appreciate it. And there are so many people out in the public who have just given of their hearts and their time, and I just really appreciate it, and Chris really appreciates it. There were so many times when Chris would tell me, John, thank them, thank everybody, tell them thank you. And so we just appreciate you showing up today. And this is all good, and this is all for Chris. Thank you.
You can walk.
I gave your mom my address and number.
Thank you. Thank you.